Before we start with this, Counsel, you've been here for a while. I just want to thank you for your patience. We've had a couple of interesting cases before and we've run late. That won't affect in any way how we address your case, and if we need to run late, we will as well. This is case number 23-3091, Walgreen Company versus Monica Papalardo and Dynaserve Florida LLC. Counsel, how much time for rebuttal would you like?
Your Honor, 5 minutes.
You may proceed when you like.
May it please the court, Peter Webster for the appellant, Walgreen Company. Appellee Dynaserve argued in its answer brief that the order granting summary judgment in its favor and against plaintiff was an appealable final order and that therefore this court lacked jurisdiction to review it. I believe that our response in our reply brief established that that argument in fact lacks merit, and therefore I don't intend to address it today unless the court has questions about it. So first, I'll address the issue of whether the trial court erroneously granted summary judgment in favor of Dynaserve and against plaintiff on plaintiff's claim against Dynaserve. In its initial brief, we asserted the trial court should have asked only one question in deciding the duty issue. And of course, duty was the sole ground on which summary judgment was granted in favor of the plaintiff. And that question should have been, was it foreseeable that if Dynaserve failed to use reasonable care in carrying out its acknowledged contractual obligations to Walgreen, including immediately notifying Walgreen about hazards and other safety problems on the property, it was likely people coming onto the property could be injured in some way.
So the duty, it would appear, is exclusively coming from the contract between Walgreens and Dynaserve?
Yes, Your Honor.
So when we look at that particular contract, I view it as a very detailed contract. Certainly Walgreens is specifying in extraordinary detail how the outside of its stores are supposed to be addressed. It goes so far as to say how many times you have to fertilize the plants. So I want to ask you about the no third-party beneficiaries provision in there. It specifically says that you are not going to, it doesn't intend to create any sort of legal or equitable right, benefit, or remedy of any nature whatsoever. I understand from the initial brief that your position is that that only relates to third-party contractual beneficiaries. My question is, in a contract where Walgreens could dictate how many times the plants were fertilized, couldn't it say that it only applied to contractual third-party beneficiaries?
Well, Your Honor, the case law, I think, is fairly clear that a provision of this type, in fact, one of the cases they cite says this, a provision of this type relates to the ability of third parties to bring contract claims as intended third-party beneficiaries. Dynaserve, in its briefing in the trial court, and the trial court, in fact, in its order granting summary judgment to plaintiff, cited a case The case is Wilson Green versus City of Miami, third DCA case, which quoted from another third DCA case, Maryland Maintenance Services versus Palmieri, and they cited that case for the proposition that a defendant's, where a contract exists, a defendant's liability extends to persons foreseeably injured by the defendant's failure to use reasonable care in the performance of the contractual promise.
Counsel, is it your position then that a contract could never disclaim that obligation?
Absolutely not, because in fact, Dynaserve cited some cases where the contracts had done precisely that.
That's actually an interesting question, because like, it actually goes to two issues. Does the contract create a tort duty to third parties, right? And then does the third-party beneficiary provision disclaim it? And it seems to me you'd have to separate those, because assuming a tort duty was otherwise created in the absence of the third-party beneficiary provision, normally when you have a tort duty to someone, in order to disclaim it, they have to disclaim it. So in other words, if you have a contract or anything else that creates a tort duty to some third party, and here it came from a contract, that third party would have to disclaim the tort duty or, waive your liability for negligence. So it doesn't actually sound crazy to me that a contract couldn't waive that duty to third parties.
Well, what it does is the duty in a situation like this is actually the contractual duty is to the other contracting party. And the duty to third persons who are injured as a result of negligent performance of that contract is a completely different situation, and all the case law recognizes that distinction.
Exactly. It's just like, the contract may create the tort duty, but once you have a duty in tort, if somebody wants to disclaim it, they have to disclaim it. I would kind of analogize it to, if somebody was a subcontractor on a building and they, built something poorly, the fact that they would be liable in tort for that if somebody was injured, right? The fact that the contractor they work for disclaimed third-party liability would have nothing to do with the person who was physically injured by the thing they built.
It would be much like the waivers of liability that occur in sporting events or stock car racing, where if somebody wants to participate in that and the party that's actually putting on the event wants to avoid liability for injuries that person who's participating might suffer as a result of participating, they ask the participant to sign a waiver of liability. And I think that's what you're talking about here.
Yeah, like in negligence, I guess the analogy would be the negligent security, right? So, sports team hires security company to protect everyone in an event. Someone comes in and injures a bunch of people at the event. The fact that the contract between the sports team owner and the security company disclaimed third-party liability, nobody would say the persons who were shot by the negligent security couldn't sue the security company.
So the situation here, what happened here, and in fact, Dynaserve and the trial court acknowledged that privity of contract was not necessary for the plaintiff to sue them here, and that whether they had a duty was to be determined by the foreseeability analysis. It's a simple foreseeability analysis. It doesn't matter whether you're talking about the owner of the property or somebody who's engaged to perform a service for the owner.
Now, in both of those hypotheticals, it's a little bit different because the security company is actually supposed to be protecting people, right? And the person who, builds something as a subcontractor is supposed to build it safely. Here, they didn't have a duty to fix the sidewalk or to keep the sidewalk safe.
Correct.
They only had the duty to warn Walgreens. Does that make it different than those hypotheticals?
Well, I think that if we ask the question, and I don't think there's any dispute about the proposition that the case we start with to determine whether a duty exists is McCain versus Florida Power Corporation. And in McCain, what happened in that case is precisely, we submit, what happened here. The District Court of Appeal, the second district in McCain, had conflated duty and proximate causation. In fact, the Supreme Court in McCain said The district court below erred in that it confused the duty and proximate causation elements, resulting in a mistaken assumption that Florida Power's duty was to foresee the specific sequence of events that led to McCain's injury. This approach, in effect, allowed the duty element to subsume the question of proximate causation. So, according to McCain, to determine whether there's a duty, you ask one question: was it foreseeable that the defendant's conduct created a broader zone of risk that poses a general threat of harm to others?
So understanding McCain's general proposition, is there anything from the Florida Supreme Court that's analogous to your client's case? You know, when I look at the, Wilson Green and I look at Palmieri, those are District Court of Appeals cases. Is there anything from the Florida Supreme Court on this subject that doesn't involve a professional services contract, like architecture or engineering?
I can't off the top of my head come up with a Supreme Court decision. There is the third district decision that the court in Wilson Green cited.
It's Palmieri, right?
Actually, yes, it is.
Yeah, so Palmieri is the service at the
Calder Racetrack.
Yes. So I guess my question, just being a court that's not bound by sister court precedent, is there anything that directs us? And I recognize the quality of the brief. I recognize the quality of the firm that prepared the brief. I couldn't find anything. I appreciate your candor.
Well, and I think the answer to that, Your Honor, is to go back again to McCain.
Counsel, if I could ask you about
Yes.
McCain. So, in this case, do you agree that for purposes of the pleading, the elevated sidewalk was in existence before the appellee came onto the property to do their weekly visit or whatever it was?
Yes.
Okay. And so, at that time, that risk was there, correct?
Yes.
And not because of anything the appellee did.
Absolutely not.
So how do they create or expand or in any way increase this zone of risk that already exists by going onto the property and then failing to notify Walgreens?
Well, I would submit to Your Honor that the answer to that is sort of common sense. They had a duty to immediately report to Walgreens problems of this type. They admitted that. They admitted that they failed to report this problem. and
Well, they didn't admit that they saw the problem and failed to report it, did they?
they admitted they failed to report it, and at her deposition, their representative said, we should have seen that.
So the testimony, your argument is based on the testimony that we didn't see it, but we should have.
Well, either they didn't see it, but they should have, or they did see it. In either case, they didn't report.
Okay.
And they had a duty contractually to report to Walgreens. Now, how does that broaden the zone of risk? Well, gosh, the evidence was that had Walgreens been informed about this problem, they'd have fixed it.
Is there an inherent different level of risk in a parking lot that's being accurately respected and having defects reported on it, and a parking lot that is not being accurately inspected and having defects reported on it to the person who could fix it? It seems to me if you have a parking lot, one's being inspected and defects reported, one not being inspected and defects not reported, those parking lots pose two different levels of risk.
Sure, the one where there are no inspections and therefore of necessity no reports creates a much broader initial zone of risk. because nobody really knows what's out there.
Yeah.
But-
But they contracted to make this a parking lot that was an inspected parking lot.
To
right?
reduce the risk, to reduce the zone of risk, and there is case law
So they
on that
didn't-
issue.
Counsel, so you're saying is they didn't reduce it, but they also didn't increase it. It was what it was, right?
They didn't,
They didn't reduce the likelihood of possible correction that may have avoided the injury
No.
because they failed to report it.
what they did is create a broader zone of risk to business invitees because they failed to report the problem to Walgreen, and Walgreen, had it known about the problem, would have fixed it. And that broadens, or at least it doesn't lessen the zone of risk. And in McCain,
And I'm sorry, I guess a related question to what the chief asked. Is there a Florida Supreme Court case that has taken this create zone of risk language of McCain and applied that in a failure of a contracting party to notify the other contracting party of a hazardous, dangerous condition on the property?
well, in McCain itself, Your Honor, the court said, where defendant's conduct creates a foreseeable zone of risk.
Right, but in the facts of McCain, that wasn't a failure to warn, was it?
No, but what the court said was, where defendant's conduct creates a foreseeable zone of risk, the law generally will recognize a duty placed upon the defendant either to lessen the risk or see that sufficient precautions are taken to protect others from the harm that the risk poses.
Would that be dicta as with respect to a failure to warn, since that wasn't at issue? in
Well,
McCain?
surely failure to warn was not an issue, a direct issue at least, in McCain. But
Are there any DCA cases where it's a failure to warn in that context? Because in Palmieri, it was a failure to act, to clean up the spill. In Wilson Green, it was a failure to act. Dynaserve can't act under the terms of this particular contract. Is there any DCA case where there's a failure to warn?
Your Honor, the act here was the failure to notify Walgreen. That's the negligent act, and that's what broadened the zone of risk. And the problem,
It's an omission, right? And I understand that we're equated, that the act is the failure to act. I'm just asking if there's anything that can give us any guidance from any of our sister courts.
is there a red cow case? I haven't found one.
Thank you for that.
What is a red cow case?
Well,
counsel?
it's a case that's exactly identical in all respects to, and we never.
I would just take an animal case as opposed to the red cow. Is there a case where there's a failure to warn in this particular context from a DCA case? And look, I'm not saying that we wouldn't do it, but are you asking us to write the first case in Florida jurisprudence that would reverse on these grounds?
I think where the problem is arising here, Your Honor, is exactly where it arose in the trial court. And by the way, Dynaserve didn't respond to our arguments regarding duty at all in their brief. They made tit-to-coachman arguments. But I think the problem here is what happened in the trial court, and that is we start looking at particular cases, which is what Dynaserve asked the court to do. Look at this case, look at this case. The facts in the law are all distinguishable in those cases, and this may be the first case, I don't know, but we have to go back to first principles, and the first principles are in McCain.
There's a
And
first principle too in the context of, and you've been candid in this in your briefing and I appreciate it. There's a first principle relating to the non-delegability of duty of landowners to their business invitees. How does allowing Ms. Papalardo sue Dynaserve directly not delegate your liability?
well,
Delegate your duty, I'm sorry.
The law is perfectly clear, Your Honor. We cited at least half a dozen cases in our briefing for the proposition that the fact that a non-delegable duty to maintain the property exists has no bearing on whether Dynaserve had a separate duty to the plaintiff by virtue of its contract with Walgreen, which contract, by the way, it agrees it breached. It failed to report this. For whatever reason, it failed to report it. It had a duty to do that. I see my time is up, and
Time flies. Thank you, counsel.
thank you.
Counsel.
Good afternoon. May it please the court, I'm Chip George, and I represent Dynaserve, and I'm also a proud graduate of Berry University. We have to keep in mind, we got to keep this in the proper context. The proper context is, this is a premises liability case. My client can be held responsible for those acts which create a danger on the property. My client can be held responsible for, directly the plaintiff, for those acts which broaden an existing danger. And as Walgreens tells you, we did neither. So as a result, in order to hold us responsible in premises liability, this is different from everything else. In premises liability, because the owner has the non-delegable duty, for us to take on the owner's duty, we have to have a contract. We have to assume that duty somehow, whether it be in writing, verbally, or by action.
Counsel, if you could answer Judge Mize's question to your opposing counsel, and that is, given you agree, you didn't dispute that your client had a duty to notify Walgreens of defects in the property like this. Do you agree with that?
Oh, I agree with that.
Okay. So if you have that contractual duty, setting aside what agreements and modifications and how you might tweak that with your opposing contracting party, as to the plaintiff, that's my question, and now I'll ask it to be making my question, is if you're going to get a waiver, doesn't that have to come from the plaintiff?
I think we're looking at, and I understand what your question is, I understand what you're asking, and there is no waiver. I'm going to answer the question directly. There is no waiver from the plaintiff, obviously.
Sure.
But I think the question becomes, because we did not do something directly which caused the injury, we didn't raise the sidewalk panel, we didn't raise it further, we don't know how that got there. Since we did not raise the panel, in order for plaintiffs to sue us, and the case law is very clear about this, it has to be a contractually and or assumed duty to plaintiff.
Counsel, but that comes down to whether you increase the zone of risk. And is there not an inherent different level of risk between an inspected parking lot and an uninspected parking lot? Your client essentially turned what was supposed to be an inspected parking lot into an uninspected one. Those pose two different levels of risk. Walgreens contracted, they had an uninspected parking lot, right? They entered into a contract with you, make this an inspected parking lot, an additional landscaping. And instead of making an inspected parking lot, you made it an uninspected parking lot.
In our situation, we had, my guy had a lawn care guy. He cuts the grass, he
Counsel, he contracted for more than lawn care.
I understand that.
He was also a parking lot inspection guy.
My point is, and I apologize for not answering the question. We had an obligation to inform Walgreens of those things which we noticed, which we believed to be a danger. And we did not have a right to protect, fix, repair, correct, and as a
You didn't just have a
result.
duty to report what you saw, you had a duty to look, didn't you?
I'm sorry,
You didn't just have a duty to report anything you happened to see by chance. Your client had a duty to look. correct?
We have an obligation to report to them those items which we see and which we deem to be a hazard. That's what the contract said. From there, for that clause of the contract to become actionable, the law has to give us an ability to protect ourselves somehow. We gotta have the right to fix it, barricade it, preclude people from entering the area.
Well, hold
No
on,
access.
hold on. Wasn't the way to protect yourself to not be negligent? I mean, I think you just, when you said we have to have a duty to protect himself, why is that the case? I mean, it's not like every defendant who has a negligence claim brought against them, oh, well, there must have been something we could do. The answer to that question is always, don't be negligent. That's how you protect yourself.
In this particular case, because it's premises liability, and because we do not have a duty, as a contractor to the plaintiff, unless we assume some duty to the plaintiff.
Well, but counsel, let me ask you this, in a hypothetical. If you're doing your landscape and one of your personnel starts, they're supposed to plant some new vegetation. So they start digging holes, dig 4 holes all over the property. They leave, don't mark the area, don't do anything. Do you have a duty to the plaintiff when the plaintiff falls into one of the holes?
We
Did
created
you
the
breach
risk.
a duty when the plaintiff
created
falls
the
into
risk.
the hole?
We have an obligation, we created the risk.
Okay, so that's your distinction is in that
That is
case,
the
you
distinction.
created that hole as opposed to the sidewalk, which is really undisputed, you had nothing to do with.
If we expanded the hole,
Assuming it actually existed as a defect.
we brought in and/or created the risk. And that's why McCain requires, and if you read McCain carefully, it requires, and the line of cases following it requires that you create the risk or you broaden the risk. And then you have the ability, ability is not even a good word. Everybody had the ability to protect somebody, has the right to either protect people from that risk or go in and correct the risk. And we didn't have that
Counsel,
right
yeah.
either way.
I'm sorry to interrupt, but follow up. And let's say I agree with, or we agree with your statement as to what the law is. But do you agree that we, since this is a common law concept, could, if it was an expansion of the duty, say, well, not just create and not just to make it worse, but to fail to lessen? Could we do that? And if so, why should we not?
Well, I think if you put yourself in a position where you're judging whether or you start getting into proximate cause at that point as opposed to duty, I think in the initial question has to be, does a defendant who fails to do something incur liability to a third party like plaintiff as a result of their failure to do something where they do not create the injury and the risk in the first place, expand it, or have the ability, and that's the key, have the ability to protect that person against the risk by closing off the area.
Counsel, I
marking it,
understand
or
that,
correcting
but
it.
why should we not do that? If it is an expansion, why should we not expand it? I mean, I'm sure the plaintiff's argument is somewhat being made by your
Everybody
opposing
in
counsel, and that the policy reason that courts have expanded duties over the centuries would be, we want people who are injured to have a remedy.
We would go from the point where where something that the defendant has done has foreseeably contributed to, created, and so on, like I keep talking about, without the ability to correct or protect. And as a result, we create liability on everybody in this room for just about everything they do.
Well, right.
The person who gratuitously opens the door.
That's certainly the policy argument to the contrary, that we would have to have people get sporting level tickets to go out to the grocery store and to Walgreens and all of those things.
I go into grocery stores all the time, and I'm a defense attorney. I see stuff on the floor, and I tell people, go to an employee and I say, there's something on the floor there. Does that mean that now I'm responsible for protecting and guarding and not
Well,
warning
counsel,
people?
but that's not the analogy. The analogy is if it was your job to inspect the floor, right? I mean, so say it is your job to inspect the floor of a, grocery store for spills. And, they've had increased liability, they're worried about spills, they hire an outside contractor, just walk around constantly, look for spills all the time, right? And then whoever they send, instead of looking for spills, just takes a cigarette break, right? They're out back, they don't show up, they don't look for spills, right? Would they not have a duty in tort? Now, they've been hired to look for spills and to tell Publix, Walgreens, whoever, some laundry detergent spill, go over there, before somebody trips. You're saying no duty to third parties now?
I have, in that scenario where I have an obligation to inform,
Yeah.
but I don't inform, we haven't taken the next step, which is, again, in premises liability, the ability to do something to protect and/or.
All right, so take that, right? So this was something your client came by periodically, right? They were supposed to look at it, but just micro it in terms of the time. So they've had a lot of lawsuits over slip and falls. They want to take this seriously. They hire your client. I want somebody in there 24/7, walking every aisle, looking for laundry detergent that's been spilled, right? Or whatever, shampoo, whatever, okay? It is your duty to tell me so I can clean it up lickety-split, and no one falls. Your client just gets there and doesn't do the inspecting, just does other things, plays on their phone, right, whatever. Is your client not taking on any duty to third parties there to stop spills? Do they not assume a tort duty? And Walgreens contracted to make their floor an inspected floor, right? An inspected floor with somebody constantly walking around looking at it has one level of risk. An uninspected floor has a much higher level of risk. You turned their floor from an inspected floor into an uninspected floor by failing to warn as you were required to. Did you not, in that scenario?
I think that you're making a distinction which an uninspected floor as opposed to an inspected floor I don't think it necessarily has a greater risk. I think they talk about it, and they talk about this in the third district did, I think with Judge Miller and Cascante. And I talk about Cascante case because we're talking about premises liability where we don't have a duty because we didn't create the risk or expand the risk. And as a result, the duty that we have flows directly from the contract, and the contract does not, because we do not have the ability to control the risk. And that's what premises liability is all about. It's the ability to control the risk. It's the ability to exclude people from the
In that
premises.
case, are you not part of the control? I mean, is your only objection to the hypothetical that you don't think an uninspected floor is more risky? Because I just tell you, I think it is. And you are part of the control apparatus. In order to make a decision to clean up the spill, they must know about the spill, and they've hired you to be that part of the chain. You're that step. You're the knowing about the spill part. I'm the fixing the spill part. You're the knowing the spill part, right? Those are two parts of controlling the process, and you failed to do one of them, the one that you were hired to do.
Again, I think it's a question of because we did not create the risk or expand the risk, we then have to look at the contract and determine what is actionable under the contract. And I'm going to remind you that one of the things that is in, and we started this whole conversation with this, one of the things that's in this contract is we expressly disavow any right or obligation or duty to third parties under the contract.
Is there a meaningful distinction between creating a risk and contracting to remove a risk and just not removing it?
I think there's a distinction because in creating the risk makes you directly liable, and you don't need a contract in order to create the duty. Plaintiff needs this contract to create the duty. And so the contract circumscribes the boundary of the duty. And the fact that we agreed to inform Walgreens of I forget the exact wording, so I don't want to pretend like I'm quoting. But basically it says, you're going to tell us about things that you think are wrong. the fact that we did that doesn't become actionable because plaintiff says, I got hurt. It becomes actionable only if we have the right and the ability to protect ourselves, to do something about what we're pointing out. And we don't have the right or ability to do anything. And that's why this is a duty question as opposed to a proximate cause question.
Can I ask
We
another
do not-
premises liability question? Does somebody have a duty to warn of hazards that are open and obvious?
I'm going to ask you to repeat that.
Yeah, duty to warn, open and obvious versus latent. Does the property owner have a duty to warn about hazards that are open and obvious?
Open and obvious applies as a defense for a property owner to proximate cause. Even though that danger was there, you can't hold me responsible because it was open and obvious and you failed to perceive, understand yourself. That's not our situation here. If anything, it hangs Walgreens even more because Walgreens, they talked about how they had this self-serving testimony that we would have fixed it had you told us. Well, that's nice, except the contract doesn't give us the ability to make Walgreens fix it. The contract doesn't allow us to go out there and barricade this thing or dig up the sidewalk and fix it if we see it. This isn't a situation where we left a pile of debris someplace. We allowed mold and mildew to grow on the sidewalk or something like that. This is a situation where a sidewalk adjacent to the building and off of the parking lot had a raised panel for some reason. It apparently had been there for a long time because it was all mildew, it was all brown and so on. It wasn't a clean, nice break or anything else. Apparently also, according to their testimony, they inspect all the time. We tell our employees every time we're out there, look, inspect. We would have fixed it, he said. Well, the facts are this. If you look at the testimony in depots, it took them about 9, 10, 12 weeks to fix this thing after they became aware of it. How do we know any of this? And the reason I'm bringing it up is not because it makes a difference in this case. It's far afield. What's important is we have no ability to do anything for fixing this. Walgreens is the one that retained to itself in its contract. If they wanted to put me on the hook for failure to inform them of problems and so on, they should have added another clause to this contract, and it should have been, and you will be responsible if you fail to do so because.
Can I change
And
gears?
they didn't do that.
Can I change gears on
They
you
didn't do
for a
anything
second?
like that.
If I might, could I change gears on you for a second, talking about the contract? Help me understand the contractual indemnity summary judgment. I look at that indemnification clause, and it seems to be more expansive than just negligence. It seems to talk about a breach of the contract. We've got an admitted breach of the contract on the part of your client. How was the trial court correct in granting summary judgment on that cross claim?
Wrote something down about that.
It's good.
Unfortunately, I wrote too much. I'm not gonna waste your time. The indemnity contract, if you read it carefully, says that we will indemnify them, Walgreens, for those damages which arise out of our breach of the contract. And because we cannot be held liable to plaintiff in damages for any problem, for failure to warn, inform, call it what you want.
That's the part I don't understand, because you could breach a tort duty to a third party, to a plaintiff, and Walgreens could breach a duty to a plaintiff who trips and falls or slips and falls on their particular property. But if you've got somebody whose job it is to inspect the property, tell Walgreens about it, and enters into a contract about it that contains an indemnification clause, where I struggle is how that relates to negligence at all. I could, for example, say to somebody who was completely unrelated to me, if anything bad happens to me, you're going to pay for it. They didn't cause it, they don't have anything to do with it. That's literally every insurance company that I have. So how is this different than that?
I think this is different because we did not do something, meaning we didn't create or expand.
No, now we're talking about contract. So in the contract scenario, now we're not talking about zone of risks or tort concepts. My question is about contractual principles. It seems to me that there's an agreed breach of a contract that has an indemnification provision. How are we not reversing on that ground?
But how is that's what I keep talking about. How is the duty, the obligation, call it what you want, to inform them of stuff we think might be dangerous, actionable?
Because it's a breach of the
only-
contract.
It only becomes actionable if we do something, we cause the damage, we expand the risk.
Is that the
We
case
do-
though? So I'm just asking you to think about it as a general agreement to indemnify if something happens. So in this point, the contract, the indemnification contract does talk about, yes, negligence. Let me just say I'm accepting, for the sake of my question, that your client wasn't remotely in any way negligent. They still breached the contract though, right?
I agree with that, Your Honor.
So if, as a result of the breach of the contract, Walgreens could prove in front of a trier of fact that this is what caused the plaintiff's damages, how is your client not liable as a matter of contract as opposed to tort?
Because the promise isn't actionable. I keep saying that because here's the problem. I can't do anything to fix or remedy my failure. I can't do anything. I see the sidewalk problem, and I'm not sure if it's gonna get reported or not, okay? I don't know what the guys do. Let's say I'm even aware that they don't do their paperwork right. But I can't do anything to exclude, protect, or fix. And as a result, it's not actionable because the contract does not give me the ability, the right to go in and to keep people away from that danger, to repair the danger, to do something about it. And I can't force Walgreens to do it. So as a result, the promise is almost illusory because I can't force Walgreens to do anything and I can't fix it myself, so I'm stuck. I'm stuck. There's nothing I can do about it. That's why I keep saying it's not actionable. It's not actionable because the law has to give me an out. It's got to give me an ability to either force them to fix it, and if they don't fix it and I get sued, then I can go back against them, or
Isn't the out,
just go in
though-
and fix it myself.
I understand what you're saying though, but isn't the out to write down on your sheet, I told them? So that, write down on the inspection sheet, I told them about the sidewalk. And it doesn't even necessarily have to be something like a small raise in a sidewalk. You know, the contract talks about your client reporting if, for example, somebody abandons an automobile or furniture for some reason. People are apparently abandoning furniture in Walgreens parking lots. And you just let that furniture sit there and you don't say anything about it and somebody crashes into the furniture and hurts themselves. Are you saying that in that particular case, you wouldn't have an obligation to indemnify?
In the case of the furniture, and if somebody hurt themselves on the furniture, I think I would have an obligation.
It comes from the exact same
I think
provision
that would
of
be
the
my
contract.
independent, I created and/or broadened the zone of risk. I've done something. I've
Okay.
done something. I see that I'm out of time, Your Honor. I would just like to address one point very quickly. I asked that your court read the cases which Walgreens cite in opposition to the notice of appeal as to plaintiff's judgment was untimely. Those cases deal with a situation where plaintiff continued to have other claims against the defendant. In this case, all of the issues between plaintiff and my client were resolved, and as a result, it was a final appealable order, and the notice of appeal 14, 16 months later was untimely. Thank you very much. I ask the court in conclusion, I ask that the court affirm the judgment in all respects. Thank you.
Counsel, you have 3 minutes and 50 seconds of extra rebuttal.
Thank you. And what does that give me total?
4 minutes. You're ticking up, it'll tick up to 4 minutes and then you'll be finished.
Okay, so first of all, let me just say that the summary judgment against plaintiff would have only been immediately appealable if it were a partial summary judgment under Rule 9.110K. Clearly, it was not. Secondly, we need to not lose sight of the fact that we're here appealing summary judgments. We are entitled to all reasonable inferences in our favor. We're entitled to all doubts being resolved in our favor. Everything you heard pretty much from Dynaserve relates to either proximate causation or comparative negligence. Those are fact issues. We're here on what the Supreme Court in McCain said is the minimal threshold legal requirement for opening the courthouse doors, for getting us to a jury on these claims. And the only reason we didn't get there is because the trial court incorrectly conflated proximate cause and duty. Now, the one final thing I'd like to say is that with regard to the indemnity cross claims, Judge Traver, you made the arguments I didn't get to make in my initial arguments. And that is, the only issue involved on those cross claims is whether Dynaserve breached a duty it owed under the contract to Walgreens. And they've admitted they breached the duty. Whether Walgreens is entitled to recover for that or not is a factual question, depending on the evidence regarding who was actually responsible for the problem. And that's an issue for the trier of fact. Thank you, Your Honor.
Thank you.